Assalamualaikum warahmatullahi wabarakatuh. My name is NURUL ATIKA SUHADA BINTI MUSA, and today I will explain about the crime of aggressions. So I will start. Crime of aggression, historically known as a crime against peace. Crime of aggression is used by armed force by a state against the sovereignty, integrity, or independence of another state. As for the instructions, aggression is widely regarded as a crime under customary international law, although at present there is no universally agreed definition and no international court or tribunal in existence which can try offenders. It is formally within the jurisdiction of the ICC, but the court can exercise its jurisdiction unless and until the parties of the ICC statute have agreed to both a definition of the crime and condition under which the court may be exercised its jurisdictions. This is a crime which differs from all other within the scopes in this book, is being inextricably connected with unlawful act of a state. The crime of aggression comprises the participation of the state's leaders and the policy makers in certain aggressive acts by states. To understand the crime, therefore, it is necessary to understand the rule of international law on the responsibility of states for the unlawful use of force. Adopted through the amending the Rome Statute at the first review conference of the statute in Kampala, Uganda, 2010. Despite historical curiosities, the first international trial of aggression under the name of the crime against peace was before the Nuremberg International Tribunal following the Second World War. The closest to the imperfect precedence for this trial was the provision in the 1990 treaties of Versailles after the First World War for the establishment of a special tribunal to try Kaiser Wilhelm. The intention was to try him not for aggression, but for a supreme offense against international morality and the sanctity of the treaties. A provision that was explained as having not a judicial character as regard its substance, but only in its form. The ex-emperor is arranged as a matter of high international policy. The Kaiser Wilhelm took refuge in the Netherlands and was never put on trial. Aggression is generally a leadership crime that can only be committed by those with the power to shape states' policy of aggression, rather than who carry it out. The philosophical basis for the wrongness of aggression is found in just war theory, in which waging a war without a just cause of self-defense. After the Second World War, the discussion in the United Nations War Commissions and elsewhere, which preceded the drafting of the London Charter, made it clear that it was by no means a widely held view that there existed a crime of aggression under international law as it then stood. Nevertheless, Article 6, Clause A of the Charter give the Nuremberg International Military Tribunal jurisdictions over crimes against peace. Defines as a planning, preparation, initiation, or waging of a war of aggressions, or a war in a violation of international treaties, agreements, or assurance, or participation in a common plan or conspiracy for the accomplishment of any of the foregoing. The equivalent provision in the Charter for the Tokyo International Military Tribunal, IMT, and in control Council Law number 10 were very similar. In the wake of the German invasion of the Soviet Union during the World War II, Soviet jurists around training made a first success proposal to criminalize aggressions. The Charter of the International Military Tribunal (IMT) provided criminal liability for waging aggressions war in the main focus of the Nuremberg trial. The Nuremberg IMT had to deal with the objection of the accused that the Charter created new law and then the tribunal applied law ex post facto. It dismissed this claim by ruling that ever since the 1928 Kellogg-Briand Pact, aggressive war had been a crime under international law. In the opinion of the tribunal, the solemn renunciation of a war as an instrument of national policy necessarily involved the proposition that such a war is illegal in international law, and that those who plan and wish such a war, which is inevitable and terrible consequences, are committing a crime in so doing. This reasoning was followed in a judgment of the Tokyo Tribunal, although judges ruling and PAL in their dissenting judgment agreed with it. Indeed, the 1928 Pact had not intended to give rise to an individual criminal responsibility. But whatever the merits of the decision by the two tribunals as to the status of the crimes of the Second World War, it is widely accepted that there is now a crime of aggression under customary international law. The Charter of the Tokyo IMT defined crimes against peace as planning, preparation, initiation, or waging of declared or undeclared war of aggression, or a war in a violation of international law, treaties, agreements, or assurances. Control Council Law number 10, Article 2, Clause A begin initiation of invasion of other countries and war of aggression in violation of international laws and treaties, including but not limited to planning, as in the London Charter. Aggression is one of the core crimes in international criminal law, alongside with the genocide, crimes against humanity, and war crimes. 1946, the International Military Tribunal ruled that aggression was the supreme international crime because it contained within itself the accumulated evil of the whole. The standard view is that aggression is a crime against the state that is attacked, but it can also be considered a crime against individuals who are killed or harmed as a result of war. In the 1950s, the ILC was requested to elaborate a definition of the aggressions but did not succeed in reaching agreement. The special rapporteur indeed decided that aggression by its very essence is not susceptible of definitions. After protracted negotiation in a special committee made difficult by the tension of the war in which they were conducted, a definition of aggression was finally adopted in 1974 by General Assembly Resolution 3314. The definition begins with a broad definition of aggression and then lists specific examples. Whether or not all the elements of the definition can be considered to reflect customary law With regard to the state responsibility, it is clear that the resolution does not as such provide a customary law definition for the crime of aggressions. Article 5.2 provides a war of aggression is a crime against international peace. Aggression gives rise to the international responsibility. The definition of the aggression in the draft could read in a part any act of aggression, including the employment by authorities of a state of armed force against another state for any purpose other than national of collective self-defense or in pursuance of a decision or recommendation of a competent organ of the United Nations. Threats were also included. Next, we move to the relationship to the other crimes. Aggressions is different markedly from the genocide, crimes against humanity, and war crimes, in that, unlike those crimes, it concerns the use at balloon, which the law governing recourse to conflict, and therefore raises questions of international law regarding the state responsibility for aggressive acts. Aggression provides an occasion for the commission of other crimes. In the view of the Nuremberg Tribunal, therefore, to initiate a war of aggression is not only an international crime. It is the supreme international crime, differing only from other war crimes in that it contains within itself the accumulated evil of the world. War on a major scale causes great suffering and almost inevitably involve the commission of atrocities. Although genocide has now been described as a crime of crime, there cannot be any need engaged in any abstract decision for the dreadful title of the worst international crime. A further distinction from the other crime is that while genocide, crimes against humanity, and war crimes may be, indeed typically are, committed by members of the armed force of a state or a state-like entity, aggression can be committed on behalf of a state and as a part of a state plan or policy. Further, unlike these other crimes, aggression is a leadership crime and is only committed by a person in policy-making position in the states. The Charter does not make clear connections between the prohibition on the use of force in Article 2, Paragraph 4, and the terms aggression in Article 39, or indeed armed attack in Article 51. The definition of aggression annexed to the GA Resolution 3314 is intended as guidance to the Security Council in making its determinations of aggressions under Article 39, but it is doubtful that it has been used for that purpose. The resolution defined aggression as the use of armed force by a state against sovereignty, territorial integrity, or political independence of another state, or in any other manner inconsistent with the Charter of the United Nations as set out in these definitions. In Article 3 of definition enumerates various examples of acts of aggression, specifying what, however, they are not exhaustive, and that the Security Council may conclude that they do not, in specific circumstances, constitute aggression when other acts do. Article 1 of the definition using wording similar to the in Article 2, paragraph 4 of the Charter. It may therefore be considered that aggression by a state is more or less congruent with an unlawful use of force contrary to the Article 2, paragraph 4, with the major difference that the threat of the force is not included in the definitions. Following this brief discussion, the law governing the use of force by states and what form of participation in it are criminalized. In short, the elements of the crime of aggressions. Next, we move to the condition for the exercise of ICC's jurisdictions. The crimes of aggression presupposes that an act have been committed by a state. When the ILC included aggression in its draft statute, it considered that there was a problem with the ICC trying individuals in the absence of a finding of aggressions against state concerns. The ILC proposed that in view of Security Council responsibilities under the UN Charter, the way to resolve the problem was to require that before the ICC could exercise its jurisdiction, there had to be a prior determination of the Security Council that a state had committed an act of aggression which was the subject of the proceedings. That's all from me. Thank you.